Well, jurors listened to two different accounts of a pre-dawn encounter on November 2nd of 2013 between Theodore Wafer and Renisha McBride. They began deliberating earlier today. Prosecutors argued that Wafer could have called 911 instead of opening his front door and blasting unarmed 19-year-old McBride on his front porch. But Wafer's defense attorney insisted that Wafer feared for his life when he awoke to loud pounding on his doors. Now it's up to a jury to decide whether this was a case of self-defense or murder, a decision that will likely rest upon how Wafer described those last few moments. Let's listen.
At this moment, what is going through your head?
This is trouble. This is not good.
And then what happens to you?
So I opened the door all the way as much as I could. And as soon as I did that, this person came out from the side of my house so fast. I raised the gun and shot.
And after you shot, what happened to the person on the floor?
He fell backwards, slow motion.
At that point, before you shot, did you have any idea who or how many people were outside your house?
No.
After you shot, did you get a look at the person on the porch?
Yes.
What could you tell? How long did you look?
It wasn't but a second. Like I said, dark.
Joining us now is a spokesperson for Renisha McBride's family attorney, Gerald Thurswell. He's been in the courtroom for this entire trial. Thanks so much for being here, sir.
Good evening, Julian.
Well, now, of course, we know that the jury is deliberating at this point. I think they've broken for the day. What I want you to do is give our audience an idea. What do you think they may be focusing on to come to some sort of conclusion here, some verdict in this case?
Well, first you have to understand what happened. Right after the shooting, he got in the police car, was taken to the police station, and they asked him what happened. He said, "I didn't know the gun was loaded. The gun went off by accident." He used the word accident. That's totally and completely inconsistent with a self-defense claim. Self-defense is, I shot somebody intentionally because I was in fear of great bodily harm or death. But when he got to the police station, he said it was an accident. So initially, the defense counsel went ahead and had the gun tested to see the trigger, whether or not it was a loose trigger if it really went off by accident. Defense counsel had the gun tested. Michigan State Police tested it. No, you really had to pull to get that gun to go off. Then he said to the police, "I didn't know the gun was loaded." So why would you pull a trigger on an unloaded gun? He was in his house. He was behind a steel locked door. One, he could have called 911. Two, he never had to open the door just because somebody was knocking. He could have yelled through the door, "I just called 911, I have a shotgun, go away," and the girl would have gone away.
So what we have here are conflicting testimonies here. One, we have self-defense, and he's saying it's an accident. I'm sure this will play profoundly with this jury in the deliberations.
I can't believe anybody will believe the self-defense. He's in his house. He's behind a locked steel door. He shot her through a locked screen door. All she was doing was knocking on the door. In order to claim self-defense, he has to have an honest and reasonable belief that his life is in jeopardy or that he will sustain great bodily harm.
So in other words,
he opens the door.
This will come down to whether or not, I'm sorry to cut you off, whether or not they believe his testimony in this particular case here.
Well, the question is, which testimony do you want to believe?
Exactly.
You want to believe the video recorded testimony that he gave to the police, where he said it was an accident, he doesn't know how the gun went off, he didn't think the gun was loaded? Or now do you believe when that fell through, when nobody could support that position, now he takes the position that it was self-defense? He opens the door and he sees a girl. How is an unarmed girl, 19 years old, 5'4", and he's over 6 feet, and he's got a gun and she doesn't have a weapon, how does he claim that he was in fear for his life or great bodily harm? I can't believe anybody is going to believe him. I can't believe he'll ever be acquitted.
Mr.
but he had no choice.
Mr. Thurswell, we don't have a whole lot of time here. I just want to ask, based upon what the jury was asking for readbacks, what evidence they were asking for, what indication that does that give you that they're coming close to any kind of verdict and what that verdict might be?
I think it'll take some time. They asked for the shotgun that he used to kill her, and they asked for the screen door through which he shot. Those were the two physical pieces of evidence. They also have the recorded video, the statement that he gave to the police at the police station.
Okay.
I can't believe they're going to acquit him, but you got to understand, this is a serious charge. A man's life is on the line, so they're going to take their time.
Okay, we'll exactly see what happens and see if perhaps if there may be a quick verdict perhaps tomorrow. Gerald Thurswell, thank you so much, sir.
Good night, Julian.